Hi, my name is Amanda Rocha. I am an estate planning and probate attorney in California, and today I want to talk to you about duress, capacity, and undue influence. Before I get into that, I want to give you my contact information. You can find me on my website at www.amandarocalaw.com, on social media at Amanda Rocha Law, or comment down below if this platform allows you to do that. So the reason that I wanted to talk to you about this was because in another video I was creating, I said something about duress and realized that when I say this to my clients, most of them understand the meaning of what I'm talking about, but don't know necessarily all that goes into it. So this is a great opportunity to just let you know now what most estate planning attorneys and anybody else referring to duress is talking about. So first, in California, if you want to create an estate plan, you have to be mentally competent to do so. So that means you need to be over the age of 18 and of sound mind, according to the legislature. Sound mind means that you would have testamentary capacity, which is another term that is just pretty much undefined and loaded. But basically what it means, according to the legislature, is that this person knows that they're making a will, they understand what a will is, and they understand what property they have, and they know who their relations are and who they're leaving the property to. That's basically it for testamentary capacity. So if you have capacity to create a will, that's one issue. Another issue, and this is also for trusts, by the way, another issue that can come up is whether or not that person was under duress when they created it. So the reason we talk about this really is if you have someone who is elderly when they create their estate plan with people around them that may or may not be influencing them to do this, or if they have questionable judgment or very pushy family members, sometimes people will contest a will and say they made that will under duress or undue influence. So now that you understand why we would talk about it, what is it? Duress is when someone creates something under threat of violence or constraint or under some sort of threat that an action will be taken. And it doesn't necessarily mean that they are unaware of what they're doing, but they're doing it for the wrong reason because someone is forcing them to do it. Next, undue influence is when you have someone being taken advantage of by someone in a position of trust. So this is your typical elder abuse issue generally. Unfortunately, it's when someone is told, oh, I'm going to help you create this, you need it, but then instead of leaving their property to, let's say, their family, it's left to a praying caregiver, someone who hasn't been there and maybe shouldn't be in that position. Now, don't get me wrong, there are many situations in which a caregiver is part of the family and a wonderful, beautiful person, and someone willingly left them their home or something else. That does happen all the time. But it's an easy explanation for what undue influence is for our purposes and generally law school purposes as well. So if you have any questions about any of these things, you can contact me through my website, www.amandarocalaw.com. You can comment down below if this platform allows you to do that, or you can find me on social media at Amanda Rocha Law.